Hi, this is the bare reading of Land Acquisition Act 1894. This can be listened to as an audiobook mainly for the people who do not have time to read. This is only for educational purpose and no legal advice is given in this video. More videos on the topic will be made, including explanations, history, case laws, and other details. But for now, let's just get to the bare reading of the Act. Land Acquisition Act 1894, Act Number 1 of 1894. It received the President's assent on 2nd February 1894. An act to amend the law for the acquisition of land for public purposes and for the companies. Whereas it is expedient to amend the law for the acquisition of land needed for public purposes and for companies, and for determining the amount of compensation to be made on account of such acquisitions. It is hereby enacted as follows. Part 1. Preliminary. Section 1. Short title, extent and commencement. This Act may be called the Land Acquisition Act 1894. It extends to the whole of India. Now it also applies to Jammu and Kashmir. It shall come into force on the first day of March 1894. Section 2. Repeal and saving. Section 3. Definitions. In this Act, unless there is something repugnant in the subject or context. A. The expression land includes benefits to arise out of land and things attached to the earth or permanently fastened to anything attached to the earth. The expression local authority includes a town planning authority by whatever name called, set up under any law for time being force. The expression person interested includes all persons claiming an interest in the compensation to be made on account of the acquisition of land under this Act. A person shall be deemed to be interested in land if he is interested in an easement affecting the land. The expression collector means the collector of a district and includes a deputy commissioner and any officer specially appointed by the appropriate government to perform the functions of a collector under this Act. The expression corporation owned or controlled by the state means any body corporate established by or under a central, provincial or state act and includes a government company as defined in section 617 of the Companies Act 1956. A society registered under the Societies Registration Act 1860 and under any corresponding law for the time being in force in a state, being a society established or administered by government and a cooperative society within the meaning of any law relating to cooperative society for the time being in force in any state, being a cooperative society in which not less than 51% of the paid up share capital is held by the central government or by the state government or governments or partly by the central government and partly by one or more state governments. The expression court means a principal civil court of original jurisdiction unless the appropriate government has appointed, as it is hereby empowered to do, a special judicial officer within any specified local limits to perform the functions of the court under this Act. The expression company means a company is defined in Section 3 of Companies Act 1956 other than a government company referred in Clause CC. A society registered under the Societies Registration Act 1860 or under any corresponding law for the time being in force in a state other than a society referred in clause CC. A cooperative society within the meaning of any law relating to cooperative societies for the time being in force in any state other than a cooperative society referred to in clause CC. The expression appropriate government means in relation to acquisition of land for the purpose of union, the central government, and in relation to acquisition of land for other purposes, the state government. The expression public purpose includes the provision of village sites or the extension, planned development, or improvement of existing village sites. The provision of land for town or rural planning. The provision of land for planned development of land for public funds in pursuance of any scheme or policy of government and subsequent disposal thereof in whole or in part by lease, assignment, or outright sale with the object of securing further development as planned. The provision of land for a corporation owned or controlled by the state. The provision of land for residential purposes to the poor or landless or to the persons residing in areas affected by natural calamities or to persons displaced or affected by reason of implementation of any scheme undertaken by the government, any local authority, or a corporation owned or controlled by the state. The provision of land for carrying out any educational, housing, health, or slum clearance scheme sponsored by government or by any authority established by government for carrying out any such scheme or with the prior approval of the appropriate government or by a local authority or a society registered under the Societies Registration Act 1860 or under any corresponding law for the time being in force in a state or a cooperative society within the meaning of any law relating to cooperative societies for the time being in force in any state. The provision of land for any other scheme of development sponsored by government or with the prior approval of the appropriate government by a local authority. The provision of any premises or building for locating a public office, but does not include acquisition of land for companies. The following persons shall be deemed persons entitled to act as and to the extent hereinafter provided. Trustees for other persons beneficially interested shall be deemed the persons entitled to act with reference to any such case, and that to the same extent as the persons beneficially interested could have acted if free from disability. A married woman, in cases to which the English law is applicable, shall be deemed the person so entitled to act, and whether of full age or not, to the same extent as if she were unmarried and of full age. And the guardians of minors and the committees or managers of lunatics or idiots shall be deemed respectively the persons so entitled to act to the same extent as the minors, lunatics, or idiots themselves, if free from disability, could have acted, provided that no person shall be deemed entitled to act whose interests in the subject matter shall be shown to the satisfaction of the collector or court to be adverse to the interest of the person interested for whom he would otherwise be entitled to act. In every such case, the person interested may appear by a next friend, or in default of his appearance, by a next friend, the collector or court, as the case may be, shall appoint a guardian for the case to act on his behalf in the conduct thereof. The provisions of order 31 of the first schedule to the Code of Civil Procedure 1908 shall mutus mutandis apply in the case of persons interested appearing before a collector or court by next friend or by a guardian for the case in proceedings under this act, and no person entitled to act shall be competent to receive the compensation money payable to the person for whom he is entitled to act, unless he would have been competent to alienate the land and receive and give a good discharge for the purchase money on a voluntary sale. We won't be reading any comments. Part 2. Acquisitions. Preliminary investigation. Section 4. Publication of preliminary notification and powers of officers thereupon. 1. Whenever it appears to the appropriate government that land in any locality is needed or is likely to be needed for any public purpose or for a company, a notification to that effect shall be published in the official gazette and in 2 daily newspapers circulating in that locality, of which at least one shall be in the regional language. And the collector shall cause public notice of the substance of such notification to be given at convenient places in the said locality. The last of the dates of such publication and the giving of such public notice being hereinafter referred to as the date of publication of the notification. 2. Thereupon it shall be lawful for any officer, either generally or specifically authorized by any government in this behalf or for his servants and workmen, to enter upon and survey and take levels of any land in such locality, to dig or bore into the subsoil, to do all other acts necessary to ascertain whether the land is adapted for such purpose, to set out the boundaries of the land proposed to be taken and the intended line of work, if any, proposed to be made thereon, to mark such levels, boundaries, lines by placing marks, cutting, and trenches, and where otherwise the survey cannot be completed, and the levels taken and the boundaries and lines marked, to cut down and clear away any part of any standing crop, fence, or jungle, provided that no person shall enter into any building or upon any enclosed court or garden attached to a dwelling house, unless with the consent of the occupier thereof, without previously giving such occupier at least 7 days' notice in return of his intention to do so. Section 5. Payment for damage. The officer so authorized shall, at the time of such entry, pay or tender payment for all necessary damage to be done as aforesaid, and in case of dispute as to the sufficiency of the amount so paid or tendered, he shall at once refer the dispute to decision of collector or other civil revenue officer of the district, and such decision shall be final. 5a. Hearing of objections. Any person interested in any land which has been notified under Section 4, subsection 1, as being needed or likely to be needed for public purpose or for a company, may, within 30 days of the date of publication of the notification, subject to the acquisition of land or of any land in the locality as the case may be. 2. Every objection under subsection 1 shall be made to the collector in writing, and the collector shall give the objector an opportunity of being heard in person or by any person authorized by him in his behalf or by pleader, and shall, after hearing all such objections and after making such further inquiry, if any, as he thinks necessary, either by making a report in respect of the land in which has been notified under section 4 subsection 1, or make different reports in respect of different parcels of such land to the appropriate government, containing his recommendation on the objections, together with the record of the proceeding held by him for the decision of that court. Government. The decision of the appropriate government on the objections shall be final. For the purposes of this section, a person shall be deemed to be interested in land who would be entitled to claim an interest in compensation if the land were acquired under this act. Declaration. Section 6. Declaration that land is required for a public purpose. Subsection 1. Subject to the provisions of Part 7 of this Act, when the appropriate government is satisfied after considering the report, if any, made under Section 5A, subsection 2, that any particular land is needed for public purpose or for a company, a declaration shall be made to that effect under the signatory of a secretary to such government or of some officer duly authorized to certify its orders, and different declarations may be made from time to time in respect of different parcels of any land covered by the same notification under section 4 subsection 1, irrespective of whether one report or different reports has or have been made wherever required under section 5A subsection 2. Provided that no declaration in respect of any particular land covered by a notification under section 4 subsection 1, published after the commencement of land acquisition amendment and validation ordinance 1967, but before the commencement of the Land Acquisition Act 1984, shall be made after the expiry of 3 years from the date of the publication of notification. Published after the commencement of the Land Acquisition Amendment Act 1984 shall be made after the expiry of 1 year from the date of publication of the notification. Provided further that no such declaration shall be made unless the compensation to be awarded for such property is to be paid by a company or wholly or partly out of public revenues or some fund controlled or managed by a local authority. Explanation 1. In computing any of the periods referred to in the first proviso, the period during which any action or proceeding to be taken in pursuance of the notification issued under section 4 subsection 1 is stayed by an order of the code shall be excluded. Explanation 2. Where the compensation to be awarded for such property is to be made out of the funds of a corporation owned or controlled by the state, such compensation shall be deemed to be compensation paid out of public revenues. 2. Every declaration shall be published in the official gazette and in 2 daily newspapers circulating in the locality in which the land is situate, of which at least one shall be of regional language, and the collector shall cause public notice of the substance of such declaration to be given at convenient places in the said locality, the last of the dates of such publication and the giving of such public notice being hereinafter referred to as the date of publication of the declaration, and such declaration shall state the district or other territorial division in which the land is situate, the purpose for which it is needed, its approximate area, and where a plan shall have been made of the land, the place where such plan may be inspected. The said declaration shall be conclusive evidence that the land is needed for a public purpose or for a company, as the case may be. And after making such declaration, the appropriate government may require the land in a manner hereinafter appearing. Section 7. After declaration, collector to take order for acquisition. Whenever any land shall have been so declared to be needed for a public purpose or for a company, the appropriate government or some official. So it's Diwali season and children are playing outside with firecrackers. I'm sorry for the interruption. Let's just read the last para again. Section 7. After declaration, collector to take order for acquisition. Whenever any land shall have been so declared to be needed for a public purpose or for a company, the appropriate government or some official authorized by the appropriate government in this behalf shall direct the collector to take order for the acquisition of the land. Section 8. Land to be marked out, measured and planned. The collector shall thereupon cause the land, unless it has been already marked out under section 4, to be marked out. He shall also cause it to be measured, and if no plan has been made thereof, a plan to be made of the same. Section 9. Notice to persons interested. The collector shall then cause public notice to be given at convenient places or near the land to be taken, stating that the government intends to take possession of the land and that claims to compensation for all interest in such land may be made to him. Such notice shall state the particulars of the land so needed, and shall require all persons interested in the land to appear personally or by agent before the collector at a time and place therein mentioned. Such time not being earlier than 15 days after date of publication of such notice, and to state the nature of their respective interest in the land and the amount and particulars of their claims to compensation for such interests and their objections, if any, to the measurements made under section 8. The collector may in any case require such statement to be made in writing and signed by the party or his agent. The collector shall also serve notice to the same effect on the occupier, if any of such land or on all such persons known or believed to be interested therein, or to be entitled to act for persons so interested as reside or have agents authorized to receive such service on their behalf within the revenue district in which the land is situate. In case any person so interested resides elsewhere and has no such agent, the notice shall be sent to him by post in a letter addressed to him at his last known residence, address, or place of business, and registered under section 28 and 29 of the Indian Post Office Act 1898. Section 10. Power to require and endorse the making of statements and to names and interests. The collector may also require such person to make or deliver to him at a time and place mentioned, such time not being earlier than 15 days after the date of requisition, a statement containing, so far as may be practicable, the name of every other person possessing any interest in the land, or any person thereof, as co-proprietor, sub-proprietor, mortgagee, tenant, or otherwise, and of the nature of such interest and of the rents, profits, if any, received and receivable on account thereof for 3 years next proceeding the date of the statement. Every person required to make or deliver a statement under this section or section 9 shall be deemed to be legally bound to do so within the meaning of sections 175 and 176 of Indian Penal Code. Inquiry into measurements, value and claims and award by the collector. Section 11. Inquiry and award by the collector. 1. On the day so fixed or any other day to which the inquiry has been adjourned, the collector shall proceed to inquire into the objections, if any, which any person interested has stated pursuant to a notice given under section 9 to the measurements made under section 8 and into the value of the land as at the date of the publication of notification under section 4 subsection 1 and into the respective interest of the persons claiming the compensation, and shall make an award under his hand of the true area of the land, the compensation which his opinion should be allowed for the land, and the apportionment of the land of the said compensation among all the persons known or believed to be interested in the land, of whom or of whose claims he has information, whether or not they have respectively appeared before him. Provided that no award shall be made by the collector under this subsection without the previous approval of the appropriate government or of such officer as the appropriate government may authorize in his behalf. Provided further that it shall be competent for the appropriate government to direct that the collector may make such award without such approval in such class of cases as the appropriate government may specify in this behalf. 2. Notwithstanding anything contained in subsection 1, if at any stage of the proceeding the collector is satisfied that all the persons interested in the land who appeared before him have agreed in writing on the matters to be included in the award of the collector in the form prescribed by rules made by the appropriate government, he may, without making further inquiry, make an award according to the terms of such agreement. 3. The determination of compensation for any land under subsection 2 shall not, in any way, affect the determination of compensation in respect of other lands in the same locality or elsewhere in accordance with the provisions of this Act. 4. Notwithstanding anything contained in the Registration Act 1908, no agreement made under subsection 2 shall be liable to registration under the Act. Section 11A. Period within which an award shall be made. The collector shall make an award under section 11 within a period of 2 years from the date of publication of the declaration, and if no award is made within that period, the entire proceedings for the acquisition of land shall lapse. Provided that in a case where the said declaration has been published before the commencement of the Land Acquisition Amendment Act 1984, the award shall be made within a period of 2 years from such commencements. Explanation. In computing the period of 2 years referred to in this section, the period during which any action or proceedings to be taken in pursuance of such declaration is stayed by an order of the court shall be excluded. Section 12. Award of collector when to be final. 1. Such award shall be filed in the collector's office and shall, except as hereinafter provided, be final and conclusive evidence, as between the collector and the persons interested, whether they have respectively appeared before the collector or not, of the true area and the value of the land and the apportionment of the compensation among the persons interested. 2. The collector shall give immediate notice of his award to such of the persons interested as are not present personally but by their representatives when the award is made. Section 13. Adjournment of inquiry. The collector may, for any cause he thinks fit, from time to time adjourn the inquiry to a day to be fixed by him. Section 13A. Correction of clerical errors, etc. 1. The collector may, at any time, but not later than 6 months from the date of the award, or where he has been required under Section 18 to make a reference to the court before the making of such reference by order, correct any clerical or arithmetical mistakes in the award or errors arising therein, either on his own motion or on application of any person interested or a local authority, provided that no correction which is likely to affect prejudicially any person shall be made unless such person has been given a reasonable opportunity of making a representation in the matter. 2. The collector shall give immediate notice of any corrections made in the award to all the persons interested. 3. Where any excess amount is provided to have been paid to any person as a result of the correction made under subsection 1, the excess amount so paid shall be liable to be refunded in the case of an default or refusal to pay. The same may be recovered as an arrear of land revenue. Section 14. Power to summon and enforce attendance of witnesses and production of documents. For the purposes of inquiry under this Act, the collector shall have the power to summon and enforce the attendance of witnesses, including the parties interested or any of them, and to compel the production of documents by the same means and as so far as may be, in the same manner as is provided in the case of a civil court under the Civil Code of Procedure. Section 15. Matters to be considered and neglected. In determining the amount of compensation, the collector shall be guided by the provisions contained in Section 23 and 24. Section 15A. Power to call for records, etc. The appropriate government may at any time before the award is made by the collector under Section 11 call for any record of any proceedings, whether by way of inquiry or otherwise, for the purpose of satisfying itself as to the legality or propriety of any finding or order passed, or as to the regularity of such proceedings, and may pass such order or issue such direction in relation thereto as it may think fit, provided that the appropriate government shall not pass or issue any order or direction prejudicially to any person without affording such person a reasonable opportunity of being heard. Taking possession. Section 16. Power to take possession. When the collector has made an award under Section 11, he may take possession of the land, which shall thereupon vest absolutely in the government, free from all encumbrances. Okay. Section 17. Special powers in case of urgency. In case of urgency, whenever the appropriate government so directs, the collector, though no such award has been made, may on the expiration of 15 days from the publication of the notice mentioned in Section 9, subsection 1, take possession of any land needed for the public purpose. Such land shall thereupon vest absolutely in government, free from all encumbrances. 2. Whenever, owing to any sudden change in the channel of any navigable river or other unforeseen emergency, it becomes necessary for any railway administration to acquire the immediate possession of any land for the maintenance of their tariff, or for the purpose of making thereon a river side or ghat station, or of providing convenient connection with or access to any such station, or the appropriate government considers it necessary to acquire the immediate possession of any land for the purpose of maintaining any structure or system pertaining to irrigation, water supply, drainage, road communication, or electricity, The collector may, immediately after the publication of the notice mentioned in subsection 1 and with the previous sanction of the appropriate government, enter upon and take possession of such land which shall thereupon vest absolutely in the government, free from all encumbrances. Provided that the collector shall not take possession of any building or part of building under the subsection without giving to the occupier thereof at least 48 hours notice of his intention to do so, or such longer notice as may be reasonably sufficient to enable such occupier to remove his movable property from such building without unnecessary inconvenience. 3. In every case under either of the preceding subsections, the collector shall, at the time of taking possession, offer to the persons interested compensation for the standing crops and trees, if any, on such land, and for any other damage sustained by them caused by such sudden disposition, and not accepted in section 24, and in case such offer is not accepted, the value of such crops and trees and the amount of such other damage shall be allowed for in awarding compensation for the land under the provisions herein contained. 3a. Before taking possession of the land under subsection 1 of subsection 2, the collector shall, without prejudice to the provisions of subsection 3, tender payment of 80 per centum of the compensation of such land as is estimated by him to the persons interested entitled thereto, and paid to them unless prevented by one or more of the contingencies mentioned in section 31 subsection 2. And where the collector is so prevented, the provisions of section 31 subsection 2, except the second proviso thereto, shall apply as they apply to the payment of compensation under that section. 3b. The amount paid or deposited under subsection 3a shall be taken into account for determining the amount of compensation required to be tendered under section 31, and with amount so paid or deposited exceeds the compensation awarded by the collector under section 11, the excess may, unless refunded within 3 months from the date of the collector's award, be recovered as an arrear of land revenue. 4. In the case of any land to which, in the opinion of the appropriate government, the provisions of subsection 1 or subsection 2 are applicable, the appropriate government may direct that the provisions of sections 5a shall not apply, and if it does so direct, a declaration may be made under section 6 in respect of the land at any time after the date of publication of such notification under section 4 subsection 1. Part 3. Reference to court and procedure thereon. Section 18. Reference to court. 1. Any person interested who has not accepted the award may, by return application to the collector, require that the matter be referred by the collector for the determination of the court, whether his objection to the measurement of the land, the amount of compensation, the persons to whom it is payable, or the apportionment of the compensation among the persons interested. 2. The application shall state the ground on which the objection of the award is taken, provided that every such application shall be made if the person making it was present or represented before the collector at any time when he made his award within 6 weeks from the date of the collector's award. In other cases, within 6 weeks of the receipt of the notice from the collector under section 12, subsection 2, or within 6 months from the date of collector's award, whichever period shall first expire. Section 19. Collector's statement to the court. In making the reference, the collector shall state, for the information of the court in writing under his hand a situation and extent of land, the situation and extent of land with particulars of any tree, buildings, or standing crops thereon, the names of the persons whom he has reasons to think interested in such land, the amount awarded for damages and paid or tendered under section 5 and 17 and either of them, and the amount of compensation awarded under section 11. The amount paid or deposited under subsection 3A of section 17, and if the objection to be to the amount of compensation, the grounds on which the amount of compensation was determined. 2. To the said statement shall be attached a schedule giving the particulars of the notice served upon and of the statements in writing made or delivered by the parties interested, respectively. Section 20. Service of notice. The court shall thereupon cause a notice specifying the day on which the court will proceed to determine the objection and directing their appearance before the court on that day to be served on the following persons, namely the applicant, all persons interested in the objection except such, if any, of them as have consented without protest to receive payment of the compensation awarded, and if the objection is in regard to the area of the land or to the amount of compensation, the collector. Section 21. Restrictions on scope of proceedings. The scope of the enquiry in every such proceeding shall be restricted to a consideration of the interests of the person affected by the objection. Section 22. Proceedings to be in open court. Every such proceeding shall take place in open court, and all persons entitled to practice in any civil court in the state shall be entitled to appear, plead, and act, as the case may be, in such proceeding. Section 23. Matters to be considered in determining compensation. 1. In determining the amount of compensation to be awarded for land acquired under this Act, the court shall take into consideration: first, the market value of the land at the date of publication of the notification under section 4, subsection 1. Secondly, the damage sustained by the person interested by reason of taking of any standing crops or trees which may be on the land at the time of collectors taking possession thereof. Thirdly, the damage, if any, sustained by the person interested at the time of the collectors taking possession of the land by reason of severing such land from his other land. Fourthly, the damage, if any, sustained by the person interested at the time of the collectors taking possession of the land by reason of the acquisition injuriously affecting his other property, movable or immovable, in any other manner, or his earnings. Fifthly, if in consequence of the acquisition of land by the collector, the person interested in is compelled to change his residence or place of business, the reasonable expense, if any, incidented to such change. And sixthly, the damage, if any, bona fide resulting from diminution of the profits of the land between the time of the publication of declaration under the section 6 and time of collectors taking possession of the land. 1A. In addition to the market value of the land as above provided, the court shall in every case award an amount calculated at the rate of 12% per centum per annum on such market value for the period commencing on, or on such market value for the period commencing on and from the date of publication of notification under section 4. Subsection 1. In respect of such land to the date of the award of the collector or the date of taking possession of the land, whichever is earlier. Explanation. In computing the period referred to in this subsection, any period or periods during which proceedings for the acquisition of land were held up on account of any stay or injunction by the order of any court shall be excluded. In addition to the market value of the land as above provided, the court shall in every case award a sum of 30% on such market value in consideration of the compulsory nature of the acquisition. Section 24. Matters to be neglected in determining compensation. But the court shall not take into consideration, first, the degree of urgency which has led to the acquisition. Secondly, any disinclination of the person to part with the land acquired. Thirdly, any damage sustained by him which, if caused by a private person, would not render such person liable to a suit. Fourthly, any damage which is likely to be caused to the land acquired after the date of publication of the declaration under section 6 or by or in consequence of the use to which it will be put. Fifthly, any increase in the value of the land acquired likely to occur from the use of which it will be put when acquired. Sixthly, any increase to the value of the other land of the person interested likely to occur from the use to which the land acquired will be put. Seventhly, any outlay or improvements on or disposal of the land acquired, commenced, made, or effected without the sanction of the collector after the date of publication of the notification under section 4, subsection 1, or eighthly, any increase in the value of the land on account of its being put to use which is forbidden by law or opposed to public policy. Section 25. Amount of compensation by court not to be lower than the amount awarded by the collector. The amount of compensation awarded by the court shall not be less than the amount awarded by the collector under section 11. Section 26. Form of awards. 1. Every award under this part shall be in writing, signed by the judge, and shall specify the amount awarded under clause 1st of subsection 1 of section 23, and also the amounts, if any, respectively awarded under each of other clauses of the same subsection, together with the grounds of awarding each of the said amounts. 2. Every such award shall be deemed to be a decree, and the statement of the grounds of every such award a judgment within the meaning of section 2, clause 2, and section 2, clause 9, respectively, of the Code of Civil Procedure 1908. Section 27. Costs. 1. Every such award shall also state the amount of costs incurred in the proceedings under this part, and by what persons and in what proportions they are to be paid. 2. When the award of the collector is not upheld, the costs shall ordinarily be paid by the collector, unless the court shall be of opinion that the claim of the applicant was so extravagant or that he was so negligent in putting his case before the collector that some deductions from his costs should be made, or that he should pay a part of the collector's costs. Section 28. Collector may be directed to pay interest on excess compensation if the sum which, in the opinion of the court, the collector ought to have awarded as compensation is in excess of the sum which the collector did award as compensation. The award of the court may direct that the collector shall pay interest on such excess at the rate of 9% per annum from the date on which he took possession of the land to the date of payment of such excess into the court. provided that the land of the court, provided that the award of the court may also direct that where such excess or any part thereof is paid into court after the date of expiry of a period of 1 year from the date on which possession is taken, interest at the rate of 15% per annum shall be payable from the date of expiry of the said period of 1 year on the amount of such excess or part thereof which has not been paid into court before the date of such expiry. Section 28A, redetermination of the amount of compensation on the basis of the award of the court. 1. Where in an award under this part, the court allows the applicant any amount of compensation in excess of the amount awarded by the collector under Section 11, the persons interested in all other land covered by the same notification under Section 4, subsection 1, and who are also aggrieved by the award of the collector may, notwithstanding that they had not made an application to the collector under Section 18, by return application to the collector within 3 months from the date of the award of the court, require that the amount of compensation payable to them may be redetermined on the basis of the amount of compensation awarded by the court. Provided that in computing the period of 3 months within which an application to the collector shall be made under this subsection, the day on which the award was pronounced and the time requisite for obtaining a copy of the award shall be excluded. 2. The collector shall, on receipt of the application under subsection 1, conduct an inquiry after giving notice to all the persons interested and giving them a reasonable opportunity of being heard, and make an award determining the amount of compensation payable to the applicants. 3. Any person who has not accepted the award under Section 2 may, by return application to the collector, require that the matter be referred by the collector for the determination of the court, and the provisions of subsection 18 to 28 shall, so far as may be, apply to such references as they apply to a reference under Section 18. Part 4. Apportionment of compensation. Section 29. Particulars of apportionment to be specified. Where there are several persons interested, if such person agrees in the apportionment of the compensation, the particulars of such apportionment shall be specified in the award, and as between such persons the award shall be conclusive evidence of the correctness of the apportionment. Section 30. Dispute as to the apportionment. When the amount of compensation has been settled under Section 11, if any dispute arises as to the apportionment of the same or any part thereof, or as to the persons to whom the same or any part thereof is payable, the collector may refer such dispute to the decisions of the court. Decision of the court. Part 5. Payment. Section 31. Payment of compensation or deposit of same in court. 1. On making an award under Section 11, the collector shall tender payment of the compensation awarded by him to the persons interested entitled thereto according to the award, and shall pay it to them unless prevented by someone or more of the contingencies mentioned in the next subsection. 2. If they shall not consent to receive it, or if there be no person competent to alienate the land, or if there be any dispute as to the title to receive the compensation or as to the apportionment of it, the collector shall deposit the amount of compensation in the court to which a reference under Section 18 would be submitted, provided that any person admitted to be interested may receive such payment under protest as to the sufficiency of the amount. Provided further that no person who has received the amount otherwise than under protest as to the entitled to make any application under Section 18. Provided also that nothing herein contained shall affect the liability of any person who may receive whole or any part of any compensation awarded under this Act, to pay the same to the person lawfully entitled thereto. 3. Notwithstanding anything, in this section, the collector may, with the sanction of the appropriate government, instead of awarding a money compensation in respect of any land, make any arrangement with a person having a limited interest in such land, either by the grant of other lands in exchange, the remission of land revenue on other lands held under the same title, or in such other way as may be equitable having regard to the interests of the party concerned. 4. Nothing in the last foregoing subsection shall be construed to interfere with or limit the power of the collector to enter into any arrangement with any person interested in the land and competent to contract in respect thereof. Section 32. Investment of money deposited in respect of lands belonging to persons incompetent to alienate. 1. If any money shall be deposited in court under subsection 2 of the last preceding section, and it appears that the land in respect whereof the same was awarded belonged to any person who had no power to alienate the same, the court shall order the money to be invested in the purchase of other land to be held under the like title and conditions of ownership as the land in respect of which such money shall have been deposited was held, or if such purchase cannot be effected forthwith, then in such government or other approved securities as the court shall think fit, and shall direct the payment of the interest or other proceeds arising from such investment to the persons or persons who would for the time being have been entitled to the possession of the said land, and such money shall remain so deposited and invested until the same be applied in the purchase of such other land as aforesaid, or in payment of any person or persons becoming absolutely entitled thereto. 2. In all cases of money deposited to which this section applies, the court shall order the court of the following matters, including therein all reasonable charges and expenses incidental thereto to be paid by the collector, namely the cost of such investments as aforesaid, the cost of the orders of the payment of the interest or other proceeds of the securities upon which such monies are for the time being invested, and for the payment out of court for the principal of such money, and for all proceedings relating thereto, except such as may be occasioned by litigation between adverse claimants. Section 33. Investment of money deposited in other cases. When any money shall have been deposited in court under this Act for any cause other than that mentioned in the last preceding section, the court may, on the application of any party interested or claiming an interest in such money, order the same to be invested in such government or other approved securities as it may think proper, and may direct the court or other proceeds of government may direct the court and may direct the interest or other proceeds of any such investment to be accumulated and paid in such manner as it may consider will give the parties interested therein the same benefit therefrom as they might have had from the land in respect whereof such money shall have been deposited, or as near thereto as may be. Section 34. Payment of interest. When the amount of such compensation is paid or deposited in or before taking possession of the land, the collector shall pay the amount awarded with interest thereon at the rate of 9% per annum from the time of so taking possession until it shall have been so paid or deposited, provided that if such compensation or any part thereof is not paid or deposited within a period of 1 year from the date on which possession is taken, interest at the rate of 15% per annum shall be payable from the date of expiry of the said period of 1 year on the amount of compensation or part thereof which has not been paid or deposited before the date of such expiry. Part 6. Temporary occupation of land. Section 35. Temporary occupation of waste or arable land procedure when difference as to compensation exists. 1. Subject to the provisions of Part 7 of this Act, whenever it appears to the appropriate government that the temporary occupation or use of any waste or arable land are needed for any public purposes or for a company, the appropriate government may direct the collector to procure the land and use of the same for such term as it shall think fit, and not exceeding 3 years from the commencement of such occupation. 2. The collector shall thereupon give notice in writing to the persons interested in such land of the purpose for which the land is needed, and shall, for the occupation and use thereof of the such term as aforesaid, and for the materials, if any, to be taken therefrom, pay to them such compensation either in a gross sum of money or by monthly or other periodical payments as shall be agreed upon in writing between him and such persons respectively. In case the collector and the persons interested differ as to the sufficiency of the compensation or apportionment thereof, the collector shall refer such difference to the decision of the court. Section 36. Power to enter and take possession and compensation on restoration. 1. On payment of such compensation or on executing of such an agreement or on making a reference under Section 35, the collector may enter upon and take possession of the land and use or permit the use thereof in accordance with the terms of the said notice. 2. On the expiration of the term, the collector shall make and tender to the person interested compensation for the damage, if any, done to the land and not provided for by the agreement, and shall restore the land to the person interested therein, provided that if the land has become permanently unfit to be used for the purpose for which it was used immediately before the commencement of such term, and if the person interested shall so require, the appropriate government shall proceed under this Act to acquire the land as if it was needed permanently for a public purpose or for a company. Section 37. Difference as to the condition of land. In case the collector or persons interested differ as to the condition of the land at the expiration of the term, or as to any matter connected with the said agreement, the collector shall refer such difference to the decision of the court. Part 7. Acquisition of land for companies. Section 38. Company may be authorized to enter and survey. Repeat. Section 38A. Industrial concern to be deemed company for certain purposes. An industrial concern ordinarily employing not less than 100 workmen, owned by an individual or by an association of individuals, and not being a company, desiring to acquire land for the erection of dwelling houses for workmen employed by the concern, or for the provision of amenities directly connected therewith, shall, so far as concerns the acquisition of such land, be deemed to be a company for the purpose of this part, and the references to company in Section 4, 5A, 6, 7, and 50 shall be interpreted as references also to such concern. Section 39. Previous consent of appropriate government and execution of agreement necessary. The provision of Section 6 to 16, both inclusive, and Section 18 to 37, both inclusive, shall not be put in force in order to acquire land for a company under this part, unless with the previous consent of the appropriate government, nor unless the company shall have executed the agreement hereinafter mentioned. Section 40. Previous inquiry. 1. Such consent shall not be given unless the appropriate government is satisfied, either on the report of the collector under Section 5A, subsection 2, or by an inquiry held as hereinafter provided. A. That the purpose of the acquisition is to obtain land for the erection of house dwellings for workmen employed by the company, or for the provision of amenities directly connected therewith, or that such acquisition is needed for the construction of some building or work for a company which is engaged or is taking steps for engaging itself in an industry or work which is for a public purpose, or that such acquisition is needed for the construction of some work, and that such work is likely to prove useful to the public. 2. Such enquiry shall be held by such officer and at such time and place as the appropriate government shall appoint. 3. Such officer may summon and enforce attendance of witnesses and compel the production of documents by the same means and as far as possible in the same manner as in provided by the Code of Civil Procedure 1908 in the case of a civil suit. In the case of a civil court. Section 41. Agreement with appropriate government. If the appropriate government is satisfied after considering the report, if any of the collector under Section 5A, subsection 2, or on the report of the officer making an inquiry under Section 40, the proposed acquisition is for any of the proposed referred to in Clause A or Clause AA or Clause B or of subsection 1 of Section 40, it shall require the company to enter into an agreement with the appropriate government, providing to the satisfaction of the appropriate government for the following matters, namely, the payment to the appropriate government for the cost of the acquisition, the transfer on such payment of the land to the company, the terms on which the land shall be held by the company, where the acquisition is for the purpose of erecting dwelling houses or the provisions of amenities connected therewith, the time within which, the conditions on which, and the manner in which the dwelling houses or amenities shall be erected or provided. 4a. The acquisition is for the construction of any building or work for a company which engaged or is taking steps for engaging itself in any industry or work which is for a public purpose, the time within which and the condition on which the building or work shall be constructed or executed, and 5. Where the acquisition is for the construction of any other work, the time within which, the conditions on which the work shall be executed and maintained, and the terms on which the public shall be entitled to use the work. Section 42. Publication of agreement. Every such agreement shall, as soon as may be after its execution, be published in the official gazette, and shall thereupon, so far as regards the terms on which the public shall be entitled to use the work, have the same effect as if it has formed part of this Act. Section 43. Section 39 to 42 shall not apply where government bound by agreement to provide land for companies. The provisions of Section 39 to 42, both inclusive, shall not apply, and the corresponding sections of the Land Acquisition Act 1870 shall be deemed never to have applied to the acquisition of land for any railway or other company for the purposes of which, under any agreement with such company, the Secretary of State for India in Council, the Secretary of State, the central government, the state government is or was bound to provide land. Section 44. How agreement with railway company may be proved. In the case of the acquisition of land for the purposes of railway company, the existence of such an agreement as is mentioned in Section 43 may be proved by the production of an printed copy thereof purporting to be printed by order of government. Section 44A. Restrictions on transfer, etc. No company for which any land is acquired under this part shall be entitled to transfer the said land or any part thereof by sale, mortgage, gift, lease, or otherwise, except with the previous sanction of the appropriate government. 44B. Land not to be acquired under this part except for certain purposes for private companies other than government companies. Notwithstanding anything contained in this Act, no land shall be acquired under this part except for the purpose mentioned in Clause A of subsection 1 of subsection 40 for a private company which is not a government company. Explanation. Private company and government company shall have the meaning respectively assigned to them in the Companies Act 1956. Part 8. Miscellaneous. Section 45. Service of notices. Services of any notice under this Act shall be made by delivering or tendering a copy thereof signed in the case of a notice under Section 4 by the officer therein mentioned, and in the case of other notice by an order of the collector or the judge. 2. Wherever it may be practicable, the service of the notice shall be made on the person therein named. 3. When such person cannot be found, the service may be made on any adult male member of the family residing with him, and if no such adult male member can be found, the notice may be served by fixing the copy on the outer door of the house in which the person therein named ordinarily dwells or carries on business, or by fixing a copy thereof in some conspicuous place in the office of the officer aforesaid, or of the collector, or in the courthouse, or as in some conspicuous part of the land to be acquired, provided that if the collector or judge shall so direct, a notice may be sent by post in a letter addressed to the person named therein at his last known residence, address, or place of business, and registered under Section 28 and 29 of the Indian Post Office Act 1898, and service of it may be proved by the production of the addressee's receipt. Section 46. Penalty for obstructing acquisition of land. Whoever willfully obstructs any person in doing any of the act authorized by Section 4 or Section 8, or willfully fills up, destroys, damages, or displaces any trench or mark made under Section 4 shall, on conviction before a magistrate, be liable to imprisonment for any term not exceeding 1 month, or to fine not exceeding 500 rupees, or to both. Section 47. Magistrate to enforce surrender. If the collector is opposed or impeded in taking possession under this Act of any land, he shall, if a magistrate, enforce the surrender of the land to himself, and if a magistrate, he shall apply to a magistrate or, within the towns of Calcutta, Madras, and Bombay, to the Commissioner of Police, and such magistrate or commissioner, as the case may be, shall enforce the surrender of the land to the collector. Section 48. Completion of acquisition not compulsory, but compensation to be awarded when not completed. 1. Except in the case provided for in Section 36, the government shall be at liberty to withdraw from the acquisition of any land of which possession has not been taken. 2. Whenever the government withdraws from any such acquisition, the collector shall determine the amount of compensation due for the damage suffered by the owner in consequence of the notice or of any proceeding thereunder, and shall pay such amount to other person interested, together with all costs reasonably incurred by him in the prosecution of the proceedings under this Act relating to the said land. 3. The provisions of Part 3 of the Act shall apply as far as may be to the determination of the compensation payable under this section. Section 49. Acquisition of part of house or building. 1. The provisions of this Act shall not be put in force for the purpose of acquiring a part only of any house, manufactory, or other building if the owner desires that the whole of such house, manufactory, or building shall so be acquired, provided that the owner may at the time before the collector has made his award under section 11 by notice in writing withdraw or modify his express desire that the whole of the such house, manufactory, or building shall be so acquired, provided also that if any acquisition shall arise as to whether any land proposed to be taken under this act does not does not form a part of the house, manufactory, or building within the meaning of this section, the collector shall refer the determination of such question to the court and shall not take the possession of such land until after the question has been determined. In deciding on such a reference, the court shall have regard to the question whether the land proposed to be taken is reasonably required for the full and unimpaired use of the house, manufactory, or building. 2. If in the case of any claim under section 23 subsection 1, thirdly by a person interested or on account of severing of the land to be acquired from his other land, the appropriate government is of the opinion that the claim is unreasonable or excessive, it may at any time before the collector has made his award order the acquisition of the whole of the land of which the land first sought to be acquired forms a part. 3. In the case last therein, before provided for, no fresh declaration or other proceedings under section 6 to 10, both inclusive, shall be necessary. For the collector shall without delay furnish a copy of the order of the appropriate government to the persons interested and shall thereafter proceed to make his award under section 11. Section 50. Acquisition of land at cost of a local authority or company. 1. Where the provisions of this act are put in force for the purpose of acquiring land at the cost of any fund controlled or managed by a local authority or of any company, the charges of and incidental to such acquisition shall be defrayed from and by such fund or company. 2. In any proceeding held before a collector or court, in such cases the local authority or company concerned may appear and adduce evidence for the purpose of determining the amount of compensation, provided that no such local authority or company shall be entitled to demand a reference under section 18. Section 51. Exemption from stamp duty and fees. No award or agreement made under this act shall be chargeable with stamp duty, and no person claiming under any such award or agreement shall be liable to pay any fees for a copy of the same. Section 51A. Acceptance of certified copy as evidence. In any proceeding under this act, a certified copy of a document registered under the Registration Act 1908, including a copy given under section 57 of that act, may be accepted as evidence of the transaction recorded in such document. Section 52. Notice in case of suits for anything done in pursuance of act. No suit or other proceeding shall be commenced or prosecuted against any person for anything done in pursuance of this act, without giving to such person a month's previous notice in writing of the intended proceeding and of the cause thereof, nor after the tender of sufficient amends. Section 53. Code of Civil Procedure to apply to proceedings before court. Save in so far as they may be inconsistent with anything contained in this act, the provisions of Code of Civil Procedure 1908 shall apply to all proceedings before the court under this act. Section 54. Appeals and proceedings before court. Subject to the provisions of Code of Civil Procedure 1908, applicable to appeals from original decrees, and notwithstanding anything to the contrary in any enactment for the time being in force, an appeal shall only lie in any proceedings under this act to the High Court. Form the award. from the award or from any part of the award of the court, and from any decree of High Court passed on such appeal as aforesaid, an appeal shall lie to Supreme Court, subject to the provisions contained in Section 110 of the Code of Civil Procedure 1908 and in order XLV thereof. Section 55. Power to make rules. 1. The appropriate government shall have the power to make rules consistent with this Act for the guidance of officers in all matters connected with its enforcement, and may from time to time alter and add to the rules so made, provided that the powers to make rules for carrying out for the purposes of Part 7 of this Act shall be exercisable by the central government, and such rules may be made for the guidance of the state government and the officers of the central government and of the state governments. Provided further that every such rule made by the central government shall be laid as soon as may be after it is made before each house of the parliament, while it is in session for a total period of 30 days, which may be comprised in one session or in 2 or more successive sessions, and if before the expiry of the session in which it is so laid or the successive session aforesaid, both houses agree in making any modifications in the rule, or both houses agree that the rules should not be made, the rule shall thereafter have effect only in such modified form, or be of no effect as the case may be. So, however, that any such modification or annulment shall be without prejudice to the validity of anything previously done under the rule. Provided also that every such rule made by the state government shall have laid as soon as may be after it is made before the state legislature. 2. The power to make, alter, add to rules under subsection 1 shall be subject to the conditions of the rules being made, altered, and added to after previous publication. All such rules, alterations, and additions shall be published in the official gazette and shall thereupon have the force of law. That's it for this act. We will also be reading the 2013 Right to Fair Compensation, Transparency in Land Acquisition, Rehabilitation and Resettlement Act. You can find the link in the description or somewhere on the video if it's already been uploaded. And the link for this PDF is also attached in the description.